Okay, let's get started. Let me start as I started our first class in this series. America and some other countries, we don't swear our allegiance to a leader. We swear our allegiance to the Constitution. It is the most important part, I think, of citizenship education, particularly on a comparative basis. Why this country is different. Because we're a nation of laws and a written constitution. And that written constitution has survived longer than any other. And it has weathered some storms. It had some meltdowns. Ronald Reagan once said that tyranny is always one generation away. And which means that documents like the Constitution, people being actively engaged in civic matters is so important. Getting young people aware that there are three branches of government. 70% of the people, according to one poll, know the names of the Three Stooges. But less than 30% can name a single Supreme Court judge. And among those Supreme Court judges they could name was Judge Judy. It makes you wonder. No wonder every year in America 50 million lawsuits are filed. 50 million lawsuits are filed. Yet those taken up by the Supreme Court number only 70 each year. And 40% of those are decided with a unanimous vote. Having a written constitution and having a judiciary that respects the rule of law is so important. So we start with the Constitution. Even, that's the federal, oath, and for other federal offices, it's a variation of the President's oath. In England, you have a different oath. This is the oath you swear in England. I do swear that I will be faithful and bear true allegiance to Her Majesty Queen Elizabeth, her heirs and successors according to law. Kind of different than America. We have the presidential oath, and for civil office, I've served in essentially a voluntary capacity for the last 20 years, including some overlap when I was working for employment in an advisory capacity in a city in which I live in. And I had to swear to the U.S. Constitution too. I had to swear to the U.S. Constitution and the California Constitution. And in our review of the Constitution, we found that judges and other civil officers in state governments and their subsidiaries have to swear to the U.S. Constitution. So it's not just the federal officers. The Constitution is our supreme law. Okay, let's talk. We'll do a quick review of some constitutional principles, kind of like a summary of the first 7 classes. That will take about less than 10 minutes because I'll speak very quickly. We'll talk about the 2020 term of the Supreme Court. We'll start next Monday, first Monday in October. And some of the cases coming up among those 70 cases that the court normally hears in a given term. We'll talk about judicial interpretation philosophies, because I think that really how Supreme Court cases are decided has more to do with the underlying judicial philosophy than who appointed them, than what party membership they are, what church they attend. So we'll talk about that. That's my hypothesis. Others could argue differently, but I think that's a good hypothesis. And I'll try to support that. Okay, constitutional principles. Let me move a little bit over to here now so I can look over my shoulder a little better. One of the principles people wanted in framing the U.S. Constitution, they didn't want a monarchy. Their experience with the English monarchy was the cause of the Revolution and the neglect by the Parliament in tempering the monarch, at least in the initial years, made them very suspicious. They knew that a union of sovereign states didn't work either. They knew that because under the Articles of Confederation, each state could veto all the actions of the other states, and taxes imposed on states were in effect voluntary. How would that work in today's America if your taxes were voluntary? I bet I could find things to object to. But the framers were also very concerned about the overreach of a democracy or the overreach of an oligarchy, a few powerful people deciding. So they looked at history, and James Madison, of course, was so important in that. Well, Thomas Jefferson was so important in the Declaration of Independence. James Madison was so important in the Constitution. I mean, he came from like Jefferson, like Washington, from people with some money. And he used a lot of that money to get about every book he could get on governmental philosophy at the time. And it would be shipped to him. When Jefferson went over to France to be our minister over there during the Revolution, he had Jefferson send him back books in effect, political science. And he came up with this. He looked at some of the ancient writings, such as Aristotle, and saying that the forms of government were basically three types: one ruler, few rulers, or many rulers. And none seemed to work perfectly. One ruler, a monarchy, can turn very easily into a tyranny. An aristocracy can turn into an oligarchy. A republic can turn into a plutocracy, plutocracy being of the rich. A democracy with many rulers can turn into anarchy. So what the Constitution came up with, and it was a compromise document, and as Benjamin Franklin famously said, and it may never have been really asked of him, but it became part of our history, when he was asked what type of government was being proposed by the Constitution, and he said, it's a republic, as long as we can keep it. And I think this is still a great experiment. So our constitutional principle, a federal government consisting of a limited central government, of delegated and enumerated powers, and state governments and subsidiaries of state governments with general governmental powers, meaning the federal government was designed to be of limited powers, but the state government would have more expansive powers, could really define what its powers would be through its own constitution. And that the supreme power in America, at least in terms of the central government, was power to the individuals, to the people. Not we the states, but we the people became a very important part of the American preamble to the U.S. Constitution. And also a federal government in which you not only divide the power between the three branches of government, but you divide the power between a central government and state governments. The 9th and 10th Amendments set forth that. And the basic concepts of a Congress, a president, a judiciary. That's the undermining, that's the foundation for the U.S. government. and the concepts of checks and balances. Men are not angels, said Madison. Not the first person that said that. Many women continue to say that. I think he meant at that time people. Maybe he meant men at that time, but I think we can say people are not angels. They need incentives and disincentives from going for regulating them in terms of their use of public power. So each of the two branches of the three branches, two were designed always to be kind of in opposition to the other one. You know, the president is to faithfully execute and defend the Constitution against foreign and domestic enemies. The Congress is to make the laws and raise the taxes and set forth the budget, subject to veto by the president. Congress confirms the principal officers of the federal government, or the Senate does, by vote and ratifies treaties. The judiciary interprets the law and attempts to make sure that the president doesn't make law and the Congress doesn't administer the government. And of course, in recent years, there's been a lot of pushback on the judiciary role. Maybe who's pushing back on the judiciary? You know, the Congress can use their impeachment powers to remove a sitting federal judge. The president, whoever is president nominates those judges, but are there the need for additional checks and balances? You know, the primary power of the Supreme Court, I mean, and one that is really one that other countries just marveled at now, and that is the ability of the Supreme Court to exercise judicial review, to negate a law or an action, negate a law by Congress or an action by the president as being unconstitutional. Now, history will show that that wasn't the original intent. That while it was written about in the Federalist paper, there was far from a consensus on that. The thought was that each branch would, in their exercise of their power to check the other branch, would say that what you're doing is unconstitutional. That's why I'm vetoing this bill. It's an unconstitutional bill. Or what you ask us to do is unconstitutional. Or your action is unconstitutional, and therefore we will use our oversight and our impeachment and removal authority. But the judicial review is part of the basic powers now of the federal government, of the Supreme Court. And it was only, it was first enshrined in Marbury versus Madison, that established the principle, and we went through the history of that during our first semester of classes. It was very cleverly done. Matter of fact, talk about a conflict of interest. The Chief Justice was ruling on a case in which he was part of the actors. He didn't get the Justice of the Peace appointments out fast enough under John Adams, and therefore this case became ripe on whether or not Thomas Jefferson, in withdrawing one, had the constitutional right to do that. And then it went into hiatus until just before the Civil War. Second time it was used in the Dred Scott decision. And some would say the Supreme Court tried to be the Congress or the president, tried to deal with keeping the country together by removing, at least temporarily, one of the disputes between the South and the North over slavery. But historians generally say now that instead of achieving that goal, the judges probably should have kept their eye more on the law and the Constitution, because what happened, it's just added to the northern concerns and the abolitionist movement and helped spark the Civil War. There are some common, the American Bar Association, I thought I removed the ABA pad. American Bar Association came up with a list of common mistakes about the Constitution. Mistake number one, particularly among younger people. Most of the population couldn't vote in federal elections under the original Constitution because, remember, it was men or a property interest, depending upon your state, have a property interest. Certainly not if you're an indigenous American or if you were a slave or a woman, very importantly. Many of the rights we enjoy today were not originally granted. And that came about through the addition of the 27 amendments, including the first 8 that is generally considered. Some say the first 10, but I think most scholars will now say the first 8 amendments to the Constitution is our Bill of Rights. Some framers of the Constitution, including James Madison, didn't think a Bill of Rights was necessary, because the more you define them, the more you suggest that if they're not on the list, they must not exist. And you may have to do some legal, be a legal pretzel to try to find some, to push one into another. But it became very important in the political sense, in the ratification of the Constitution, that a Bill of Rights was necessary to get the necessary ratification votes in so many states, and the Federalists promised to do so. But in the first Congress, there was very little energy at first in actually getting it done. It took a while in that first Congress. They finally got 12 of them out to the states for ratification. 10 came back initially within a year, and 1 came back just a few years ago. What occurred in those states in which people were clamoring for a Bill of Rights was the English Bill of Rights. The English Bill of Rights that was done by Parliament to check the power of the monarchy. And that English Bill of Rights really applied to a very small set of English people, but did apply, were some of our basic rights we now take for granted, such as freedom to elect members of Parliament without the King's or Queen's interference, freedom of speech, freedom from royal interference, freedom to petition, freedom to bear arms for self-defense, freedom from cruel and unusual punishment, freedom from taxation by royal decree without the agreement of Parliament, freedom of fines and forfeiture without a trial, freedom from armies being raised during peace times, were all granted by that. So the Bill of Rights was not necessarily an American idea. It was something people said, well, we had a Bill of Rights under the English system. Shouldn't we have one in America? And of course, it's not a single act of Congress. It was the first 8 amendments to the Constitution. The other thing the ABA points out, neither the word democracy or God appears in the Constitution, but religious freedom to exercise religion certainly is. And the First Amendment as we know it, and some say the First Amendment is the First Amendment for a reason. No, not really. It was actually the Third Amendment sent to the state. And the first two didn't get back in time, so the Third Amendment became the First Amendment. Okay, let's move on. Supreme Court meets next Monday. They have a good time. They shake hands each time they go on the bench. All of them shake hands. They have lunch together when they are in deliberations. They sing happy birthday songs to each other. They may be zealots in terms of advocating their positions in judicial philosophy, but they try to be a very civil organization, with civility being very, very important to them. But we know from Marbury versus Madison and John Marshall's decision that it's emphatically the province and duty of the judicial department to say what the law is, particularly what the Constitution is. We talked about the case against judicial review, but that's a case that seems not ripe anymore. I think that will never be an issue that the Supreme Court will ever strike down. Now, a former Chief Justice and a candidate for president one time said, "We are under a Constitution, but what the Constitution is what the judges say it is." That doesn't sound very much like a democracy, does it? Well, we're not. But it does say it sounds kind of a little arrogant, doesn't it to you? Charles Evans used, I think that was not a very civil moment when he said that in public. Justice Kagan, however, recently did an interview in which he said, we're actually, while we live in a polarized world, the justices really try to do the right thing under their views of the law. Part of our interview, the responsible thing for a court to do in these times is to remember that it has to look like a court in order to maintain a people's sense of legitimacy in the institution, which is a critical thing. Chief Justice Roberts, the other week, he went to a synagogue I believe in Manhattan, and was interviewed. And he said part of the problems the court gets involved in is because Congress or the president doesn't do their job. And they rely upon the court then to try to fix the problem. You fix it. It's too hard, or it's too political, or people will be unhappy if we did that. So we're at the beginning of the term. The justices are aligned, are about ready to start the run until May of their 70 cases. The docket is filling up with cases from the various Circuit Court of Appeals, mainly involving circuit splits in which one appeals court judge would interpret a law one way and a different circuit court in another part of the country would rule it in a different way, and they have to resolve that to provide equal protection in the laws to all Americans, to equal interpretation, similar interpretation. And cases will also come up quickly that will not involve circuit splits, that are issues that are very ripe for Supreme Court decision. So among the cases already coming up, including the DACA decision on the so-called Dreamers, and we have, how many? At one point I had the number in mind, several hundred Dreamers here at Cal State Fullerton. 800. Their deferred action on enforcement of the immigration laws. What happens there? I have a feeling in my gut that the Supreme Court is not going to be friendly to those individuals, but feel very compassionate. I think what they basically will say, probably by a 5-4 decision, is that Congress needs to do something. Even if it's costs some of the members their election, they need to do the right thing. Presidential authority will come up in many different ways in this term of the Supreme Court. The authority of the president, his immunities, and privileges will be challenged, and they're coming up through this directly and through the circuits. Gun owner rights. For 10 years, basically, the Supreme Court hasn't done a major gun owners' rights decision after setting forth that the right exists in the District of Columbia and extended that to the states. But now a whole lot of state courts have made decisions, Supreme Courts and states, going to up the federal court system now, on how far can states go in restricting gun rights. And those cases are coming up now, are percolating up for action. But one of the big cases that have been receiving a lot of popular comment has to do with Title VII of the Civil Rights Act of 1964 regarding discrimination against the gays, lesbians, transgender community. And does Title VII provide protection in the workplace to orientation or gender identification? And it's not clear where the court is going to go on this. They have 3 major cases, and they could go one way on one case and a different way on another case and punt on a third case, I guess. But we'll start seeing those things being argued. That Civil Rights Act of 1964, it covers such a major areas of law that the sexual discrimination was just one part of, and there was not a whole lot in the act on how to interpret it. And the various circuit courts of appeal, the federal, have had a problem with it. They've ruled differently. Those dominated by justices in the South and the Midwest tend to say that that is not covered by Title VII. Those on the coast, those courts of appeals tend to say they are. So the Supreme Court has to act. A big issue. Continuing challenge to the Affordable Care Act coming up from the South. Major case on a federal judge basically said when the Congress took away the requirement, the individual mandate, they took away the federal rationale for the act, and therefore the act goes down. The Court of Appeals down in that circuit is now considering that. In oral argument, it seems like they were sympathetic to the challenge against the Affordable Care Act. Whether or not they'll make that as their final ruling, we'll find out probably fairly shortly. And then there'll be an urgency to move it up to the Supreme Court, and the Supreme Court could grab it without waiting for other circuit courts to weigh in. A lot of trench warfare has occurred in past years, and a lot of cases are moving up on so-called the administrative state. And those of you who follow conservative media have heard this a whole lot. Those of you who haven't probably haven't heard a whole lot about the administrative state. But the administrative state is those federal agencies are either independent or within the executive branch that oftentimes act as not only as a legislator under delegated authority, sometimes arguably delegated authority, but as a judge, as an interpreter of those laws, and then as the judge of those laws and criminal penalties related to the law. If you so that they act in 3 different roles that seem to be, in the view of some legal scholars, inconsistent with our Constitution. But these agencies and executive branch delegations have become so expansive. How do you unwind it? How do you unwind it? Do you try to reform it rather than unwind it? Do you say that the FCC is unconstitutional? Do you say that or only if they only in the rulemaking, not in the rule interpretation? Like today, a court ruled that the FCC had the powers. The Circuit Court in District of Columbia ruled that in the opinion today, the FCC could do away with some of the laws dealing with net neutrality. But they couldn't prohibit the states from making their own. So their regulation of prohibition against the states doing it fell under constitutional test, while their ability to promulgate the rule could. So the administrative state, a big thing, and it will be interpreted in a lot of different ways in this case. One of the big cases in this area is one argued and decided a long time ago, and that's McCulloch versus Maryland. Probably some legal scholars say is the most important decision that John Marshall ever wrote. And he wrote the Marbury versus Madison, in which he said that Congress was not limited by the enumerated powers given to it by the Constitution, but powers logically arising from those enumerated powers. If they had the power to regulate commerce, they had the power to establish a Bank of the United States, and which was one of the contested issues. And Maryland, however, could not tax that bank out because the power to tax is the power to destroy, argued John Marshall. And Marshall said that for the supremacy of federal law, when federal law is logically growing out of enumerated powers. So a lot of the administrative state rests on the McCulloch versus Maryland decision, and we'll see how far the court will go this session. Criminal procedure case. Can a state decide to do away with the insanity plea? There are no insane criminals in my state. That's California.
Yeah.
If you want to be insane, go to California, kill someone. They'll let you go. But not in my state. And the Supreme Court will decide this point of criminal procedure in this session of this term of the Supreme Court. And of course, we know that the big case keeps coming up. Remember in Godfather 3, in which was it Michael Corleone said, it keeps coming back, or they keep reaching out to me. These cases keep coming up to the Supreme Court, and they try to move them back. Not now, not a good time. Please, we don't even want to hear it. Or if we're going to hear it, we're going to make a bad decision, and justices that are concerned with our bad decisions don't accept the case for argument. But there's a number of cases that keep percolating up because states whose political leadership believes that the court philosophy is now such that it would reverse Roe versus Wade if that case was actually before it now originally, but may not do it completely, but could erode it significantly. They keep pushing cases up to the Supreme Court, or they keep promulgating laws that will require a Supreme Court decision. So I expect we'll have more of those cases being decided this year. Let's move to the news. What else could be happening in the news? Anything constitutional?
Nothing.
Oh, yes.
Zero.
There is this thing about impeachment inquiry. And there's controversy over the law regarding an impeachment. As you heard in our preamble, the Constitution is pretty clear. The House does impeachment within certain areas of constitutional law, and the Senate tries it. And the Constitution is clear what it is. President, Vice President, and all civil officers of the United States, that means anyone other than the military officer, shall be removed from office for impeachment for and conviction of treason, makes sense, bribery, makes sense, or other high crimes and misdemeanors. And high crimes and misdemeanors kind of goes back to abuse of authority. Abuse of the authority granted by the Constitution is probably the most generally accepted. It's not a parking ticket. It's not a misdemeanor, as you might normally consider it. We know what the Senate role is to try it. Now, some, like the Wall Street Journal and other media, says the Speaker should have gone to the House and asked for a vote to start an inquiry. But that seems to be more of a political argument than a legal argument. The National Constitution Center and others who try to interpret this say, well, that has been done before. It was when there was more of a bipartisan nature in Washington, D.C. That there's probably not a legal reason to go to the House. Definitely, you can't impeach the president unless you have a majority vote. How you get there is up to the House to decide. I have a couple of things on our website, including a background paper done by the Congressional Research Service that was just updated this year that I call your attention to if you really want to go down deep on that. What the Speaker has done, Speaker Pelosi has done, is says, I'm directing 6 committees of Congress to look into issues that could be impeachable and then get all what you want to do, if you want to do something in that area, to the Judiciary Committee, and the Judiciary Committee will then consider developing articles of impeachment, and then deliberate on articles of impeachment, hold hearings, and hear from witnesses, and have rebuttals, and then move it to the floor of the U.S. House. So the Intelligence Committee is certainly looking into the matter of the conversation with the leader and conversation other actions regarding Ukraine, financial services, money laundering tied to Russia, foreign affairs, conversations between the president and Vladimir Putin. Putin said the other day through a spokesman he would only release his transcripts if he wanted to. So that sounds pretty definitive. And the president has no authority to release his comments. Judiciary articles of impeachments that would originate in the Judiciary Committee, Ways and Means, tax records for potential conflict of interest, and the Oversight Committee, including Jared Kushner's security clearance, foreign payments to the Trump International Hotel, and possible conflicts of interest. So we'll see what will occur. Yesterday, the Senate Republican leader, Majority Leader McConnell said, our Senate rules said we have to take it up. It's in our rules. It's not in the Constitution, but is in the Senate rules, and the Senate rules can only be changed by a 2/3 vote. Now, some pointed out that one mechanism could be that if the impeachment is voted by the House, when it goes over to the Senate, the Majority Leader could pull it up and then allow someone to, in effect, table it and have a straight up or down vote on tabling it. So we'll still see, and I think what will happen there. Last week, or 2 weeks ago, a federal judge blocked the California state law, at least temporarily, on requiring candidates for president to disclose their income tax return. Guess who that was aimed at? Presidents talked about using, revoking California's clean air waiver that allows it to enforce higher standards here in California. We'll see what happens on that coming up. Okay, let's talk about constitutional interpretation. You can almost anticipate how the Supreme Court is going to rule by looking at the underlying philosophies of the justices. They're pretty clear on what they are. So what are they? Well, you have the originalists, or purposive interpretation. What is the public meaning that would have been at the time that law became the law? What is the meaning based on the disputed language purpose at the time of approval? Now, some would even bifurcate that, but Justice Gorsuch would say that it's not something that you have to think, what would James Madison do about cell phones or helicopters looking in your backyard? You look at what their intent in terms of doing an investigation on private property without probable cause holds true for looking in someone's backyard in a helicopter as much today. The right to have records on a cell phone that are considered, that you consider as a necessary and necessary resource should not be open to the police unless they can get a search warrant for it. So those who are originalists say that we shouldn't read into the meaning. We should. What was the meaning at the time for the words at the time that the Constitution was adopted, and all 27 amendments, not just back to the 18th century, but including the 14th Amendment and the other amendments. Textualists, who are oftentimes also originalists, would say, what does it plainly say? What do the words say? Is it shall? Shall means shall. May means permissive. Is it a tax or is it a fee? Well, if you say it's a tax, it's probably a tax. Remember, that was a key issue in the Affordable Care Act. Politicians were saying, in enacting it, we're not enacting a tax, we're doing a fee, but argued that, hey, it's a tax and allowed under the Constitution, under Section 8 of Article 1, the powers of Congress. If you want to go into someone's reasoning on their judicial philosophy, Neil Gorsuch has a book out, came out over the summer. A good one to understand the originalist point of view and how that is argued. Now, the Warren Court and other courts use more of a living Constitution. The Constitution evolves. It's not dead anymore. It's not, remember when God is dead? Remember that movement, God is dead? It's up to us now to kind of decide our fate. The living Constitution say, hey, you can't anticipate all these things over time. Some things work, some things don't. We should bend the Constitution or interpret the Constitution in light of contemporary times using fundamental principles discussed in the Constitution, or those inalienable rights that do not need to be in the Constitution, that are there anyway. Basic rights going back to the Declaration of Independence. Of course, to conservative justices and the originalists, it's what? What do you mean by that? That could be anything. And implicit in the living constitutionalists is what's known as substantive due process rights, existing such things as liberty, interests, and principles of human dignity. And the living constitutionalists have been very persuasive, and there's an argument in judicial philosophy for that. But the critics to that say, must the Supreme Court solve problems unresolved by the other branches of government? This is like asking mom and dad to resolve a fight when you're children, No, you resolve your battles, And when someone comes back with a bloody nose, then we'll decide whether you're gone too far. Other critics argue judges shouldn't be legislators. Let legislators be legislators, as imperfect as that might be. Judges shouldn't be social engineers or non-elected reformers. But the living constitutionalists say, well, if they hadn't, we might not even have a constitution now because society would have spun out of control. You know, there would be revolution. That, 100 years after the Civil War, and we had government-sanctioned segregated housing, segregated schools, segregated higher education, segregated juries, that 100 years was enough. So those arguments, you'll see vibrant in the debates in this court. I encourage you to look at the class on constitutional interpretation. It's free through Princeton University through the edX program. That is a great class, online class on constitutional interpretation. Okay, let's talk about applying those principles to issues that you can all identify. I certainly can identify, and that is homelessness, and particularly camping by homeless people. And think back on the competing philosophies. One philosophy says it's not our job to solve problems. It's the legislative branch of government to solve the problems, and the executive branch to take the solutions come up by the legislative branch or the authorities given by the legislative branch to the executive branch and apply those to solve the problem. Well, we'll find here in the issue of homelessness many of the daunting issues facing the Constitution today. So let's drill down a little bit. Do you all remember the camping along the Santa Ana River? This was almost a worldwide image of Orange County, or at least the city of Anaheim, that had society come unglued in Orange County. This great American, the American dream. Is this the American dream? To live as a homeless person? No matter which political philosophy you have, there's a general agreement that 500,000 Americans go homeless every night in the United States. And about a third of those, almost 200,000, are found sleeping unsheltered on our streets in places not intended for human habitations, such as sidewalks and parks and cars or abandoned vehicles. We know that the count that is done by agencies receiving federal assistance on the homeless issues, they have to one day every January go out and count the homeless people. How do you count homeless people? Well, you set one day and you cover this area and you go 1, 2, 3, 4, let's see, 5. Back there 6, and you come up with a count. And while some dispute the methodology used, the total number seems to be fairly static or a little declining. Still, if you just look at the homeless veterans count, over almost 40,000 veterans go homeless every day in America, or at least that day in January in America. The 3 biggest areas in the nation on the increase in homelessness: New York, San Francisco, Los Angeles, are big ones. We've gotten a lot of homeless people, People, in other states say, why can't we solve it? And we say, you solve it. It's a difficult issue to solve. But you look at a map of America, and you do see how this is a regional issue. On the coast, in Nevada, Florida, New York State, primarily, of course, the 5 boroughs of New York. One of the issues is that we have a lot of poor people in America compared to other nations. Even when you take into account the governmental assistance, we have a lot of poor people. And we know that the cost of housing, particularly in areas such as San Francisco and Los Angeles and New York, has gone up. It's hard to be poor and be housed if you choose to be in those metropolitan areas. Either choose by explicit action, or that's where you are when you became homeless. We saw just the other day in the LA Times an article about the state of emergency is being sought to deal with the homeless problem. That is, just use some heightened governmental authorities that you can do under a state of emergency. Sweep aside some procedural laws in order to deal with the homeless. Just here in Orange County, one study by the United Way pointed out there were 6,800 people experiencing homeless. I think I have a short video on that. So there's general recognition that homelessness is a major problem. I don't think anyone here would dispute that. City of Fullerton has a website as part of their municipal website, and just on the issue of homeless. They have a task force working on homeless issues. Yet, Fullerton and many other cities and counties in California and across the nation are fighting an appeals court decision regarding the rights of homeless people not to be criminalized if there is no shelter available. And that law raises the constitutional issues we'll discuss in our remaining time today. The Court of Appeals in Boise, that has jurisdiction over Boise, decided that laws punishing homeless people for sleeping in public, that is, in camping, are cruel and unusual under the 8th Amendment to the Constitution and cannot be enforced. The decision basically says that just as the court has struck down decisions in the past about public drunkenness affecting alcoholics, that being a homeless should be struck down if there is no place where you can find shelter in that community that would not lead to you being considered homeless. So that So on the Boise decision, they said that until the city of Boise provides enough public shelters, or in cooperation with the private sector, private shelters, without religious tests, which was one of the problems there. They had one church did provide shelter and had a little bit of issues regarding whether or not the church was trying to do a religious message, and then you had to leave if you weren't part of the church after 30 days. So it was a transitional, temporary housing. The court said that wasn't enough. That wasn't enough. So in that, so what the court also said was, however, we're not saying that Boise has to produce that. You just can't enforce the law if you don't. You just can't enforce the law. If you don't have it, or some days you have it, enough capacity, you can enforce it on those days. Or if you have a portion of town, you say that people can go and camp through a place decision, or a time they can do it. They can do it from midnight to 6 a.m. time, place, and manner type of regulation that usually stands constitutional test. There's also a case here in Orange County in which the right to shelter is being litigated too, accusing the county of Orange and certain cities in Orange County of violations of the plaintiff's rights under the First, Fourth, Fifth, Eighth, and 14th Amendments to the Constitution. Some cities have joined in the lawsuit in providing shelter in order to get out of any penalties the court may do. The city of Bellflower joined, agrees to shelter homeless people to avoid being part of the lawsuit. The argument that is made by the city of Fullerton, city of San Clemente in separate lawsuits filed by very large law firms is basically this. There are practical issues in meeting the court's mandate in the Boise decision. What do you do about sanitary issues? Public defecation, public urination. What do you do about the runoff from that? What do you do if you're in an area that has a fire hazard? You don't want people camping, such as in Malibu. You don't want people to have sparks create a fire that it endangers the people. And what if you're so concerned about being sued as a governmental authority that you just step back and do nothing? You wash your hands, but then you're sued by plaintiff attorneys, civil rights attorneys, that can recover not only actual damages and punitive damages, but the cost of litigation too. That if we do nothing, we get sued. If we do something, we're going to get sued. What are we going to do? And no one's giving us enough money to do it. Everyone always uses that argument. It's true oftentimes. No one ever gives us enough money to do what someone else wants us to do. So that's what makes this such an interesting constitutional argument. The homeless advocates, the homeless legal advocates say, don't put us in jail just by being homeless. The city of Bakersfield police chief says, hey, I got room in my jail. I'll put them in jail if they have we'll find some reason to put them in jail, which is always of some type of dubious constitutional issue. Because I say, well, for having drugs or being in violation of some law, put them in jail. Of course, I'll need more money, city council, to do that, because guess what? It costs a lot more money to put someone in jail and keep them in jail than to put them in a public shelter or do some cost splitting with some type of voluntary group, such as the United Way or even some churches that don't, proselytize, or at least proselytizes with some type of option for people. The cities also argue, listen, homeless is a difficult issue. You got homeless people with animals. What do we do with the animals? What do we do with the animals? I have homeless people that have serious and violent behavior. Do I have to kind of segregate them from the other homeless people? Why me? Why me as a local government to do that? And the court, at least in their decision, is because you've enforced the law against homelessness. You criminalized homelessness. Now, what will the Supreme Court say? Well, if you look at some of the originalists, they may say, find that in the Constitution. Is that really cruel and unusual punishment? Was that kind of within the definition of cruel and unusual punishment at the time of the adoption of the Constitution, or how you interpreted cruel and unusual? They wouldn't say being poor was cruel. Yes, it's cruel, but it didn't reach the test. So this is a real case. Now, you have the homeless issue, and you have good appeals, and I have those things on the website. Please go and look at this. And the state of California has appropriated lots of money for homeless support activities and homeless shelters. County of Los Angeles passed a tax measure to do it. But we'll see how the courts end up. We also have this situation that occurs, that I have to plead knowledge of it, but luckily not of my jurisdiction when I was working, that a city would take their homeless people and move it to the Skid Row of another city. And we solved our homeless problem, boss. That's what they say, I guess. Or give them money to get on the bus and go to the end of the line. That's how they solve the homeless problem. Is that right? And sometimes on, indigent patients were then taken from the hospital and moved to an area. LA, during their urban renewal process in the Bunker Hill area, designated what was an 80 block area that they would provide concentrated homeless services, thinking that would make a lot of good sense, and they moved those homeless people into, into housing and then into jobs and what have you. Just became a dumping ground for other cities, hospitals. When you're done with your homeless, you take them and drop them at Skid Row. And the LA problem just never became solvable because it just became overwhelming. Okay, how about panhandling? Have you ever seen this? I'm not going to ask, have you ever been this? But have you ever seen this? Food or money will help feed my kids. Please help them. Which is a good thing to help them. The Bay Area Rapid Transit System in San Francisco area is facing threats of a lawsuit over a ban on panhandling and performing on BART lines inside the transits themselves. Where do we end? What do we do about panhandling? Well, panhandling, that is begging, seems to be constitutionally protected. Most federal courts interpret it as being constitutionally protected. There is not, just as there's not a Supreme Court decision, what lawyers would call on point, dealing specifically with homeless camping, there is not a case specifically dealing with panhandling on point. But there are some cases that have been used, like the Hare Krishna's religion, where basically begging at the airport was found to be that they could be banned from there as long as there's other places in the jurisdiction where they could beg. It's not, in order to exercise your First Amendment right of speech, it just can't be convenient speech. Just can't be comforting speech. It can be annoying speech, as long as it isn't accompanied by, an assault or in an area that, that would lead to a high level of public safety. Even the perception of public safety is generally not enough. That if you feel like someone's running after you, asking you for money. I remember that guy in the wheelchair that ran after me, or kind of wheeled after me that one time when I went down to Los Angeles Street to buy a suit. Kept saying, "You're not going to give me any money? Not going to give me any money?" And I kind of was scurrying around. I really felt crummy after that. But that's constitutionally protected. Someone can run after you. There was no threat to me. It was just kind of like being publicly shamed. So Pat can donate to the homeless. To divert them. Get her! But it's the first, the issues generally on the panhandling falls within the First Amendment. And the First Amendment is freedom of speech, the things on point on this. Freedom of speech, freedom of expression. And they fall, local governments can restrict it, generally speaking. They have to overcome the First Amendment challenge, and they have to overcome the 14th Amendment. No state nor shall deprive any person of liberty or property without due process of law, or the equal protection of laws. I'll go into incorporation some other day. But there's basically, when you restrict a constitutional right, generally a fundamental constitutional right, generally considered one of the 8 amendments, though the court has not explicitly said the first 8, but in cases they tend to use the strict scrutiny test on laws that restrict people's use of the Bill of Rights at the state level and local government level. And that is that the government, where the government restricts that action, you have to demonstrate to the courts a compelling government interest that is narrowly tailored to that interest. In other words, it can't be anything. You have to prove that maybe even the least intrusive or constraining measure that could be considered. And if you haven't considered that, the court will throw it out under the strict scrutiny rules for when an ordinance or statute or action comes before the court. So that you start as a local government or a state government or the federal government. Basically, the presumption is essentially against you. It's against you. You've got to prove to the court the legitimacy of your purpose. It's not that you have a purpose. Yes? Someone say something? And therefore, that's why it's so hard to do these panhandling and homeless issues. On panhandling, the basic thing, and I see this in the commission I serve on all the time, and that is that you can do, generally speaking, content-neutral time, place, and manner regulations. That is that you can't prohibit an action 100%, but you can say if you can reasonably, and that's up to a court and facts come out in a trial, reasonably restrict the time when it can be done. Though it can't be a time in which it becomes useless. If you can't say that you can only panhandle from 2 a.m. to 5 a.m. On Thursdays, that would be too restrictive. But you can say, you can put restrictions on. Place, you can say not there, but over there. And as long as over there is not demonstrably different than over here, you probably can get away with it. And the manner in which it occurs. For example, the public soapbox. You know, that you can, in a park. That's a public place. You probably aren't going to restrict someone for either trying to proselytize you to any belief, religious, political, economic belief. That's probably constitutionally protected. But you might be able to say, hey, you can talk 5 minutes. If there's 10 people in that line, each of you can talk up to 5 minutes, and you can get back in line and come up and talk again. But you just can't dominate it. That would probably be a reasonable test under time, place, and manner. So, the Constitution is always evolving. It's evolving not necessarily in its law, but on the issues that's brought to the courts to decide. What you and I and all our brethren must do is be aware that if the courts decide something, it's oftentimes because of a failure of the other branches of government or the levels of our federal system in dealing with it. They decided, using strict scrutiny, that you could inter Japanese residents in the West Coast into relocation camps because there was a compelling governmental interest. That doesn't mean that always when you apply these rules they come out the way you think they should. Of course, this court eventually, just recently, vacated that Karamazov decision, but keep that in mind. Now, let me end on something. I think I have time still. Let me end on, well, one, I'll be back next Thursday on the Trump presidency, and then back in 2 weeks on Money News. But this, the British Supreme Court. How many of you know about the British Supreme Court? I wasn't even sure there was a British Supreme Court until recently it ruled against Boris Johnson. And actually, the Supreme Court in Great Britain is fairly new. It used to be part of the House of Lords decided on what was constitutional or not. So-called law lords. Law lords, kind of a great name. Where are you? I'm a law lord. And that was moved about a decade ago to an actual Supreme Court of the United Kingdom. Now remember, the United Kingdom doesn't have a written constitution. So how do you deal with constitutional issues? Well, you go way back in time and look at what has occurred, what was the intent, and you kind of make it up. This is the Chief Justice. She is the Chief Justice of the UK, and she's a Lord. And they ruled unanimously that Boris Johnson, when he sent Parliament home for, 5-6 weeks, that's too long. There's nothing in law that says how long is too long, but that's too long. And that was unconstitutional, and unanimously those justices of the UK. Now, she's also known as a Spider Woman. Why? Look at her brooch, which she wore. She wore on her robes. Kind of also sent a message back to Boris Johnson. It's not a lifetime appointment let's compare the Supreme Court to the two, a little comparative government here. So U.S. has a constitution, it's written. Great Britain has a constitution, it's not written. The U.S. has a Supreme Court in which the justices are appointed by the executive and confirmed by the upper house. The Brits do too. It's nominated by the Queen, but the Queen's nominations come from the Prime Minister or from the Cabinet. The difference is that they aren't appointed for life. Their law lords have a retirement age. of 70 or 75, and it depended upon their transitions from the House of Commons. So some that were already in were able to serve a little bit longer. Remember, not contemporaneously, but Franklin Roosevelt tried to put on age, retirement limits on his Supreme Court when it wasn't ruling for him. And then, even though that legislation went down, and probably is constitutional, may be constitutional. Who would interpret that? That the court changed their opinions on the rest of the New Deal right after that. But their retirement is 70 versus 75. So, let me conclude today. Contemporary constitutional issues I think are interesting. They are somewhat frustrating. And I think issues such as homelessness. It's one thing if it was 1970 era Alabama, Mississippi burning time, that there's a white knight. Let's see. So there's a good guy and a bad guy in those things. So many times you look at cases that come before the Supreme Court or have to be dealt with the judiciary, it's because of the failure of someone to do their role. Presidential power I think is a contemporary one we'll see in the impeachment stuff. Every president wants the maximum amount of power possible, and find after a while a Congress that is divided or not controlled by his or her party to be very inconvenient. And they initially find a judiciary appointed by predecessors to be inconvenient. And they push out. They push out authority out. And it's up to the other branches to kind of push it back in if they're doing their constitutional role. Some would say it's kind of like what was the old line in the mob? It's not personal, it's business. And you'll enjoy the being with Hoffa. But the key point is, please come back and we'll explore some other contemporary issues. Please study the stuff on the website. It's not homework. To see how difficult these issues are. In the Boise case, the city argued, well, we don't even run the shelter system. The county has responsibility. Do we have to be responsible for only ours or within the county? Well, I'm sure some of those things could be interpreted out. I think the key arguments is, how far does the Constitution restrict government's ability to deal with homelessness or so many of our other contemporary issues? Come back and we'll explore some more. Thank you.